Proceed. So friends, let's move towards part 3 of BNSS versus CrPC. Today we'll cover section from 264 onwards till 397 to 400. And in last part, we'll cover remaining sections. So let me share screen with you. Just hold on. I'm opening the Google Drive folder. Yes. See, let me take to that particular sections. At the end of this session, we'll see some practicalities of advocacy as usual. And after completing these all parts, then we will start separate sections, separate part also with the old as well as a new act and with case laws also we'll see. But I don't want any brand of criminal lawyer or civil lawyer or corporate lawyer like that. So I will regularly cover different type of subjects. So no tag should be labeled to me. $264. Yes. We have completed in last part from this chapter 20 and in CrPC chapter 19, trial of warrant cases by magistrate. We covered A part. Now we are moving towards B part. Cases instituted otherwise than on police report. In BNSS section 267, evidence for prosecution. Its earlier section was in CrPC 244. BNSS section 268, when accused shall be discharged. Its earlier section was in CrPC 245. BNSS section 269, procedure where accused is not discharged. Its earlier section was in CrPC 246. BNSS section 270, evidence for defense. Its earlier section was in CrPC 247. Now, chapter 20, part C of BNSS. Conclusion of trial. BNSS section 271, acquittal or conviction. Its earlier section was in CrPC 248. BNSS section 272, absence of complaint. Its earlier section was in CRPC 249. BNSS section 273. Compensation for acquisition without reasonable cause. Its earlier section was in CRPC 250. Now, chapter 21 of BNSS, trial of summons cases by magistrate. Its earlier chapter was in CRPC chapter 20, trial of summons cases by magistrate. BNSS section 274, substance of acquisition to be stated. Its earlier section was in CRPC 251. BNSS section 275, conviction on plea of guilty. Its earlier section was in CRPC 252. BNSS section 276, conviction on plea of guilty in absence of accused in petty cases. Its earlier section was in CRPC 253. BNSS section 277, procedure when not convicted. Its earlier section was in CRPC 254. BNSS section 278, acquittal or conviction. Its earlier section was in CRPC 255. BNSS section 279, non-appearance or death of complainant. Its earlier section was in CRPC 256. BNSS section 280, withdrawal of complaint. Its earlier section was in CRPC 257. BNSS section 281, power to stop proceedings in certain cases. Its earlier section was 258 in CRPC. BNSS section 282, power of court to convert summons cases into warrant cases. Its earlier section was in CRPC 259. Now, chapter 22, summary trials. Its earlier chapter was in CRPC chapter 21, summary trials. BNSS section 283, power to try summarily. BNSS section 283(2), summary trial for imprisonment up to 3 years. Its earlier section was in CRPC 261 and subclause 1, summary trial for imprisonment up to 2 years. This is the main difference. Earlier summary trial was up to 2 years. Now summary trial was up to 3 years. This is a major difference. BNSS section 283(3), BNSS section 284, summary trial by magistrate of second class. Its earlier section was in CRPC 261. BNSS section 285, procedure for summary trials. Its earlier section was in CRPC 262. BNSS section 286, record in summary trials. Its earlier section was in CRPC 263. BNSS section 287, judgment in cases tried summarily. Its earlier section was in CRPC 264. BNSS section 288, language of record and judgment. Its earlier section was in CRPC 265. Now, chapter 23, plea bargaining. Its earlier chapter was in CRPC chapter 21A, plea bargaining. BNSS section 289, application of chapter. Its earlier section was in CRPC 265A, application of the chapter. BNSS section 290, application of plea bargaining. Its earlier section was in CRPC 265B. BNSS section 291, guidelines for mutually satisfactory deposition. Its earlier section was in CRPC 265C. BNSS section 292, report of mutually satisfactory deposition to be submitted before court. Its earlier section was in CRPC 265D. BNSS section 293, disposal of case. Its earlier section was in CRPC 265E. BNSS section 294, judgment of court. Its earlier section was in CRPC 265F. BNSS section 295, finality of judgment. Its earlier section was
in CrPC 265G. BNSS section 296, power of court in plea bargaining. Its earlier section was in CrPC 265H. That means plea bargaining in earlier act, that is CrPC, was in 265. So subclassification 265 A, B, C, like that. But now this subsection got the separate section number in BNSS. BNSS section 297, period of detention undergone by accused to be set off against sentence of imprisonment. Its earlier section was in CrPC 265I. BNSS section 298, savings. Its earlier section was in CrPC 265J. BNSS section 299, statements of accused not to be used. Its earlier section was in CrPC 265K. BNSS section 300, non-application of chapter. Its earlier section was in CrPC 265L. Now chapter 14 of BNSS. At BNSS section 302, power to required attendance of prisoners. Its earlier section was in CrPC 267. BNSS section 303, power of state government or central government to exclude certain persons from operation of section 302. Its earlier section was in CrPC 268. BNSS section 304, officer in charge of prison to abstain from carrying out order in certain contingencies. Its earlier section was in CrPC 269. BNSS section 305, prisoner to be brought to court in custody. Its earlier section was in CrPC 270. BNSS section 306, power to issue commission for examination of witness in person. Its earlier section was in CrPC 271. Now, chapter 25, evidence in inquiries and trials. Its earlier section was in CrPC chapter 23, evidence in inquiries and trials. Part A, BNSS, mode of taking and recording evidence. Now see some changes are there. Already some changes we have made in latest amendment of CrPC in 2000, latest amendment 2019, some 2020, like that. But now in BNSS we have changed so many things. BNSS section 307, language of court. Its earlier section was in CrPC 272. BNSS section 308, evidence to be taken in presence of accused. Its earlier section was in CrPC 273. BNSS section 309, recording summons cases and inquiries. Its earlier section was in CrPC 274. BNSS section 310, record in warrant cases. Its earlier section was in CrPC 275. BNSS section 311, record in trial before court of session. Its earlier section was in CrPC 276. BNSS section 312, language of record of evidence. Its earlier section was in CrPC 277. BNSS section 313, procedure in regard to such evidence when completed. Its earlier section was in CrPC 278. BNSS section 314, interpretation of evidence to accused or his advocate. Its earlier section was 279. BNSS section 315, remark respecting demeanor of witness. Its earlier section was in CrPC 280. BNSS section 316, record of examination of accused. Its earlier section was in CrPC 281. BNSS section 317, interpreter to be bound to be interpreted fully. Its earlier section was in CrPC 282. BNSS section 318, record in high courts. Its earlier section was in CrPC 283. Somebody will find my speed a little bit high, but somebody will find my speed a little bit slow also. Okay, that depend upon your own study. But for both the persons, there is some facilities on YouTube. When we upload this episode on YouTube, and we'll share the link in our official group of Nani Palkhiwala 1 and Nani Palkhiwala 2, NP and LC 1, NP and LC 2. So that time, when you play this on YouTube, there is a facility of YouTube. You can make it faster if you find it slow, and if you find it faster, then you can play it little bit slow also. So as per your convenience, you can increase or decrease the speed of video. Part B, commission for the examination of witness. Commissions for the examination of witnesses. It's earlier, it's a section in BNSS 319. When attendance of witness may be dispensed with and commission issued. Its earlier section was in CrPC 284. BNSS section 320, commission to whom to be issued. Its earlier section was in CrPC 285. BNSS section 321, execution of commission. Its earlier section was in CrPC 286. BNSS section 322, parties may examine witnesses. Its earlier section was in CrPC 287. BNSS section 323, return of commission. Its earlier section was in CrPC 288. BNSS section 324, adjournment of proceedings. Its earlier section was in CrPC 289. BNSS section 326, 325, execution of foreign commissions. Its earlier section was 290. Very, very important, this part is. BNSS section 326, deposition of medical witnesses. Its earlier section was in CrPC 291. BNSS section 327, identification report of magistrate. Its earlier section was in CrPC 291A. BNSS section 328, evidence of officers of Mint. Its earlier section was in CrPC 292. BNSS section 329, reports of certain governments, scientific experts. Its earlier section was 293. BNSS section 330, not formal proof of certain documents. Its earlier section was in CrPC 294. BNSS section 331, affidavit in proof of conduct of public servants. Its earlier section was in CrPC 295. BNSS section 332, evidence of formal character on affidavit. Its earlier section was in CrPC 296. BNSS section 333, authorities before whom affidavits may be sworn. Its earlier section was in CrPC 297. BNSS section 334, previous conviction or acquittal, how proved. Its earlier section was in CrPC 298. BNSS section 335, record of evidence in absence of accused. Its earlier section was in CrPC 299. BNSS section 336 is a new section, evidence of public servant, expert, police officers in certain cases. BNSS chapter 16, general provisions as to inquiries and trials. Its earlier chapter was in CrPC chapter 14. Now chapter 16. BNSS section 337, person once convicted or acquittal not to be tried for same offense.
double jeopardy. This is constitutional principle as per Article 21. BNSS section, I'm repeating again that BNSS section 337, persons once convicted or acquittal not to be tried for same offense. Its earlier section was in CrPC 300. BNSS section 338, appearance by public prosecutor. Its earlier section was in CrPC 301. BNSS section 339, permission to conduct prosecution. Its earlier section was in CrPC 302. BNSS section 340, right of person against whom proceedings are initiated to be defended. Its earlier section was in CrPC 303. BNSS section 341, legal aid to accused at state expense in certain cases. Its earlier section was in CrPC 304. So taking legal aid, taking legal help is also a directive principle of state policy of Constitution of India. So every court have this facility: Tehsil Court, District Court, High Court, and Supreme Court. Any indigent person who is needy, who is very poor, and who is needy. Not only this legal aid is not only for poor, but a person who is needy, who is not poor, but he is needy. He don't have the financial support properly at particular certain of time. So he can pray to the legal aid department to give the advocate. And if in my court, in Supreme Court, if somebody is appearing personally, every time our judges ask him, shall we provide you advocate on behalf of state? Then if he say yes, then Supreme Court judges are regularly providing one advocate from the legal aid. And if he say no, I will carry on, then he is carrying his own pleadings. Its earlier section was in CrPC 304, legal aid. Then in BNSS section 342, procedure when corporation or registered society is an accused. Its earlier section was in CrPC 305. BNSS section 343, tender of pardon to accomplice. Its earlier section was in CrPC 306. BNSS section 344, power to direct tender of pardon. Its earlier section was 307. BNSS section 345, trial of person not complying with condition of a pardon. Its earlier section was in CrPC 308. BNSS section 346, power to postpone or adjourn proceedings. Its earlier section was in CrPC 309. BNSS section 347, local inspection. Its earlier section was in CrPC 310. BNSS section 348, power to summon material witness or examine person present. Examine person present. Its earlier section was in CrPC 311. BNSS section 349, power of magistrate to order person to give specimen signatures or handwriting. Its earlier section was in CrPC 311A. BNSS section 350, expenses of complainant and witnesses. Its earlier section was in CrPC 312. BNSS section 351, power to examine accused. Its earlier section was in CrPC 313. BNSS section 352, oral argument and memorandum of argument. Its earlier section was in CrPC 314. BNSS section 353, accused person to be competent witnesses. Its earlier section was in CrPC 350. BNSS section 354, no influence to be used to induce disclosure. Its earlier section was in CrPC 316. BNSS section 355, provision for inquiries and trial being held in the absence of accused in certain cases. Its earlier section was in CrPC 317. This is a new section in BNSS section 356, inquiry
trial or judgment in absentia of proclaimed offender. So some offender, economical offender or criminal offender who are flee from the India and they are now abroad. But even though in their absentia also, inquiry and trial and judgment also will be proceeded. This is a new section and this is very good section. Once they declared any punishment, there is a procedure in international law to implement the order of this court to any foreign court. Similarly, any foreign court's judgment can be executed in India's court. There is a proper procedure and procedure is given in civil cases in CPC. There is a separate chapter for them. And same provision is given in CRPC, now BNSS. BNSS section 357, procedure where accused does not understand proceedings. Its earlier section was in CRPC 318. BNSS section 358, power to proceed against other person appearing to be guilty of offense. Its earlier section was in CRPC 319. BNSS section 359, compounding of offenses. Its earlier section was in CRPC 320. BNSS section 360, withdrawal from prosecution. Its earlier section was in CRPC 321. BNSS section 361, procedure in cases which magistrate cannot dispose of. Its earlier section was 322. BNSS section 362, procedure when after commencement of inquiry or trial, magistrate finds case should be committed. Procedure when after commencement of inquiry or trial, magistrate find case should be committed. Its earlier section was in CRPC 323. BNSS section 363, trial of persons previously convicted of offences against coinage, stamp law or property. Its earlier section was in CRPC 324. BNSS section 364, procedure when magistrate cannot pass sentence sufficiently severe. Its earlier section was in CRPC 325. BNSS section 365, conviction or commitment on evidence partly recorded by one magistrate and partly by another. Its earlier section was in CRPC 326. BNSS section 366, court to be open. Its earlier section was in CRPC 327. Now, friends, we are moving towards next chapter of BNSS, chapter 17. Provisions as to accused persons of unsound mind. Its earlier chapter was in CRPC, chapter 25. Provisions as to accused persons of unsound mind. BNSS section 367, procedure in case of accused being person of unsound mind. Its earlier section was in CRPC 328. BNSS section 368, procedure in case of person of unsound mind tried before courts. Its earlier section was in CRPC 329. Just give me a few seconds to drink water. BNSS section 369, release of a person of unsound mind pending investigation or trial. Its earlier section was in CRPC 330. BNSS section 370, resumption of inquiry or trial. Its earlier section was in CRPC 331. BNSS section 371, procedure on accused appearing before magistrate or court. Its earlier section was in CRPC 332. BNSS section 372, when accused appears to have been of sound mind. Its earlier section was in CRPC 333. BNSS section 373, judgment of acquittal on ground of unsoundness of mind. Its earlier section was in CRPC 334. BNSS section 374, person acquitted on ground of unsoundness of mind to be detained in safe custody. Its earlier section was 335. BNSS section 375, power of state government to empower officer in charge to discharge. Its earlier section was in CrPC 336. BNSS section 376, procedure where prisoner of unsound mind is reported capable of making his defense. Its earlier section was in CrPC 337. BNSS section 377, procedure where person of unsound mind detained in is declared fit to be released. Its earlier section was in CrPC 338. BNSS section 378, delivery of a person of unsound mind to care of relative or friend. Its earlier section was in CrPC 339. Now BNSS chapter 28. Provisions as to offences affecting the administration of justice. Its earlier chapter was in CrPC chapter 26. Provisions as to offences affecting the administration of justice. BNSS section 379, procedure in cases mentioned in section 215. Its earlier section was in CrPC 340. BNSS section 380, appeal. Its earlier section was in CrPC 341. BNSS section 381, power to order cost. Its earlier section was in CrPC 342. BNSS section 382, procedure of magistrate taking cognizance. Its earlier section was in CrPC 343. BNSS section 383, summary procedure for trial of giving false evidence. Its earlier section was in CrPC 344. BNSS section 384, procedure in certain cases of contempt. Its earlier section was in CrPC 345. BNSS section 385, procedure where court considers that case should not be dealt with under section 384. Its earlier section was in CrPC 346. BNSS section 386, when registrar or sub-registrar to be deemed a civil court. Its earlier section was in CrPC 347. BNSS section 387, discharge of offender on submission of apology. Its earlier section was in CrPC 348. There are so many good provisions in BNSS. Earlier they are also present in CrPC. So see this section provisions 387, discharge of offender on submission of apology. So magistrate court have so many powers. Only on apology also they can discharge any offender, but that offense should be a petty offense, not for serious offenses. BNSS section 388, imprisonment or committal of person refusing to answer or produce documents. Its earlier section was in CrPC 349. BNSS section 389, summary procedure for punishment for non-attendance by a witness in obedience to summons. Its earlier section was in CrPC 350. BNSS section 390, appeals from convictions under section 383, 384, 388, and 389. Its earlier section was in CrPC 351. BNSS section 391, certain judges and magistrate not to try certain offences when committed before themselves. Its earlier section was in CrPC 352. Now, BNSS chapter 29, the judgment. Its earlier section was in CrPC chapter 27, the judgment. BNSS section 392, judgment. Its earlier section was in CrPC 353. BNSS section 393, language and contents of judgments. Its earlier section was in CrPC 354. CrPC's one section is deleted here. Metropolitan Magistrate's Judgment 355. It is deleted now because Metropolitan Magistrate is not existence in now BNSS. That court are merged into JMFC and Chief Judicial Magistrate First Class, Chief Magistrate, then Judicial Magistrate First Class, Judicial Magistrate Second Class. They are merged now. No metropolitan city in India now. BNSS section 394, order for notifying addresses of previously convicted offenders. Its earlier section was in CrPC 356. BNSS section 395, order to pay compensation. Its earlier section was in CrPC 357. BNSS section 396, victim compensation scheme. Its earlier section was in CrPC 357A. BNSS section 396(1) to 396(6). BNSS section 396(7). Its earlier section was in CrPC 357B, compensation to be in addition to fine under section 326A or section 376D of Indian Penal Code. BNSS section 397, treatment of victims. Its earlier section was in CrPC 357C. BNSS section 398, witness protection scheme. This is a completely new section in BNSS. This section was not into existence earlier. So witness will get perfect protection now because of the section 398. BNSS section 399, compensation to a person's groundlessly arrested. Its earlier section was in CrPC 358. BNSS section 400, order to pay cost in non-cognizable cases. Its earlier section was in CrPC 359. So friend, this is this part's syllabus we have completed. Now, as usual, we are moving towards some practical tips of advocacy. So today, I will give some practical tips about property matters. So a person who is handling property cases, a lawyer who is handling property cases is really talented lawyer. This is the definition you can say. Because most complicated matters than taxation also. Income tax matter, GST matters are easier than property matters. And in property matters, specifically, when you classified some property matters, then toughest matter are division, that means succession. Succession matter are more complicated because specifically in Supreme Court is more complicated because when that matter starts in trial court and when that matter comes to Supreme Court in final appeal, not in interim orders, but in final appeal, that time minimum 1 or 2 generations are passed on. So deletion of their name, addition of their successor's name, not deleted, but name is there, but they are succeeded by their successor. And there should be a tree properly. So how anybody can handle this matter? But when you initiate your law practice, specifically when I was started my practice in 1989, my date of sanat is 14th August 1989. मुझे 15 अगस्त को चाहिए थी यार डेट, लेकिन दे नहीं पाए क्योंकि 15 अगस्त को छुट्टी रहती है ना. So Bar Council of Maharashtra and Goa office was closed. So they have taken the meeting and signed my sanad on the Independence Day of the Pakistan. Okay, ठीक है. हमारे इंडिपेंडेंट डे को नहीं मिला तो क्या हुआ, पाकिस्तान के इंडिपेंडेंट को डेट तो मिल गया, कोई बात नहीं, चलो. So after that, after I think 1 or 2 months, I got one such type of property case, very tough case, and I took that case. I took little advance also, and whole night I studied that case. But I got very, very, very pressure. How I can handle this case? This is very complicated case. So early in the morning, I got little bit doziness to get a sleep. So early in the morning, I decided to give it to client again, and we will refund his fees, and we will get rid from this such type of very heavy and dangerous matters, khatarnak matters. So I decided and slept off. But Lord Krishna ji work on my subconscious mind somehow. And when I got up from sleep after 2 hours, and then all of a sudden I get freshness. If I left this brief or I left these proceedings, then any lawyer can do that. Any other lawyer will proceed that. When any other lawyer can do that proceeding, then why I should not do that? That is a question in my mind. He is LLB, I am also LLB. He is the same qualified, I am qualified. What he will do, he will read it again, read it. I will do that. When anybody is able to handle the income tax case, why I should not? When anybody is eligible to handle the custom case, why I should not? When anybody is capable to handle the property matter, succession matter, why I should not? When anybody is handling AFT matter, armed forces matter, martial code matters, why I should not? Such type of question always give me the positive answers. Yes, you can handle. And so with the grace of Lord Krishna, I handle all these matters, all matters. Little bit we have to read. We have to go in depth. So when you get the property matter at trial level, trial court, I am now giving you practical guidelines of property matter from trial court to Supreme Court. So every court's, every judge's hunger is a different. You should know that hunger. That time you can plead properly. So in trial court, first, take the document properly, chronologically arrange the documents, okay, mark on pencil, by pencil on that particular documents. When your junior is there, you tell junior, when you are a junior, but interests are there, or your colleagues will be there, or your clerk will be there, or your associate clerk will be there. So tell him to help you there. And then write on piece of paper what you understand about the case. You try to understand the case properly. Read once, twice, thrice, whatever discussion you want, you make it client. Understand all the fact of the cases. Then see the particular law, particular sections, and then initiate drafting points only. Not initiate drafting. Now initiate drafting points. And after draft initiating point, take some pause, some gap, half hour, 1 hour gap, and then again sit. And then initiate drafting properly. And draft 1, draft 2, draft 3 sometimes. Initiate level, we have to change draft many times. So,
at draft 3 level, your draft will be okay. Then you show that draft to your client. Then whatever any point is remain balance, you can add that point. Then you can file it. Then the written statement you will get after some time. Then answer to rejoinder to a written statement. So such type of, yeah. And when you are appearing before the trial court, you should tell proper facts to the court in opening speech. Then exhibit number like that as per the CPC, trial CPC, proper plaint how plaint will proceed in properly in trial court in civil cases. When you come to appeal, that time you should find some questions of laws. And on that question of laws and some factual questions also, you can focus that. If you win in trial court, then opposite party will come to appellate court. Then you have to face that. And when you lose the case in trial court, opposite party, you have to go in appeal. Then you have to fight that case. Many times, many people are not appearing in both the courts. When anybody is appearing in trial court, he is appearing in regular trial court. He is not going in appeal court. But first appellate trial court and first appellate court is in same district or same premises. So it is always better to handle both the courts. After first appellate court, then you approach to the high court. That time, whether to appear in high court or not, that is your decision. And high court needed substantial question of laws properly. Regular question of laws also they are entertained, but they will not focus facts. So what is the error in the judgment of first appellate court? You should tell in your synopsis, list of dates properly. That should be. So your matter should get admitted as early as possible in first instance. So that is the most important thing in high courts. And after high court, in any law, high court is final appellate court in our country. But Supreme Court you can approach in all cases, because Article 136 is there. Under that article, any court's order can challenge in Supreme Court, provided that Supreme Court should accept it. So SLP, that is called special leave petition, a special leave to appeal. Special leave petition, SLP. Any judicial, non-judicial order, you can challenge it directly Supreme Court. This is the law. But except army matter, Article 136 wording is there, except army matter. Because army matter have a separate line, that is Armed Forces Tribunal. You can watch my different videos, small videos, which I have prepared in Hindi, English, combined language for understanding of the common people. So army matters in Supreme Court, income tax matter in Supreme Court, then company law matter in Supreme Court. All these videos you will find in on my YouTube channel. You can find the link in description also, or you can contact to my PA. My PA will also provide you the link. So friends, your presentation should be in a such a way, in Supreme Court specifically. Maybe you file matter through Article 136 or statutory appeal or Armed Forces Tribunal's appeal will become by the Section 30-31 of Armed Forces Tribunal. For that, Section 30 says that when Armed Forces Tribunal is giving the order, so you have to give one application to the tribunal. I'm not satisfied with this decision of the tribunal. I want to go to appeal to the Supreme Court. So please give me the permission to appeal. That is called to seek the permission to appeal in Supreme Court.
If AFT is giving you the permission to appeal in Supreme Court, you can file your appeal as per Section 30 of AFT Act. And if they deny you the appeal, they are not ready to give you they have rejected your application to file the appeal in Supreme Court, even though you can come to Supreme Court by Section 31 of AFT. This is the difference. 30, when AFT accepted the appeal, the application to proceed for appeal in Supreme Court. And 31, when AFT is not accepted the appeal to be made to the Supreme Court. So under that, even though AFT denied, you can come to Supreme Court. But that certification either accepted or denied, certification, that particular order is must mandatory before Supreme Court. So Supreme Court, AFT matter are not coming through SLBs. They are statutory appeal that one. Same way, NCALT matters are coming to Supreme Court. NCLT is a trial court of company law. NCALT is appellate court. NCLT is equivalent to high courts. NCALT, NCLAT is equivalent to high courts. And after NCLT order, yeah, and NCLT covered both the cases, competition law cases, competition law cases also covering by NCALT. So big giants like Google, Facebook are always under the scan of these laws, competition laws. Okay, so there is a special tribunal for that, and their appeal is in NCALT. Similarly, company laws appeal in NCALT. Similarly, Insolvency Acts, all appeals are NCALT. With the grace of Lord Krishna, I am also insolvency professional. I have passed that examination by attempting 8 times. 8 times I got fail result in insolvency examination, and 9 times I cleared that examination. So such a type of hard examination for me. That is not so hard for the chartered accountant or company secretary, but that is so hard for lawyers. Lawyers are not generally getting it clear, but I tried so much and I got, and now I am running 2-3 assignments also as a liquidator, as a IRP, as a. So I got the privilege to argue that cases in NCALT. Nowadays, I am not appearing in any other court than Supreme Court. Only I am appearing Supreme Court. My total law firm is totally dedicated for only Supreme Court. My 12 juniors, 5 AORs, or my law firm setup is only for Supreme Court. Whatever matter, taxation matter we are handling, SJB matter we are handling. I'm not advertising myself. This is not motto of my advertising, or this is not a motto of solicitation also. This is just I'm explaining. When we are focusing any one court, we should focus that court. Always. It is always better. I started my practice from Tehsil court to district court to Session Tribunal to High Court to Supreme Court. I have the experience of all court. But when I step ahead, when I come to High Court, I have never argued in trial court. Never. When I come to Supreme Court, I have never argued in High Court. I am not going to Delhi High Court also. This is not my proudy. This is not my proudy. This is my system. Because I have to focus one court. So I can understand each and everything. And I am very happy because I am getting chance to serve whole India. I'm serving to the people of Andaman Nicobar Islands also. I'm serving to the people of Kerala, people of Tamil Nadu, people of Andhra, people of Karnataka, people of Maharashtra, people of Gujarat, people of West Bengal, all India. Only because of that experience. If any other lawyer can do that, then why I should not do that? I'm not a talented person. I'm not a merit student. I got little bit better marks in 10th standard, but in 12th standard, higher second class. In BCom again, first class. But in LLB, higher second class. Not first class in LLB. MBA again first class. In international trade, foreign trade. But first class is not up to make excellent marks. Nowadays, excellent marks you can say more than 80%, 90% like that. So I am not a talented person, but perseverance and to get the challenges every day. Complicated cases have the way. You have to think, you have to read, you have to continuously read, you have to develop continuously reading habits, understanding, and think about the satisfaction of your client. Don't focus on money, focus on satisfaction. So I am coming again on that point. When after High Court, when you come to Supreme Court, substantial question of law should be there in your drafting. And that should be shown properly in synopsis area. In question of laws you are drafting, but some substantial question of law you can show in synopsis also. In summary, plus so some case show some case laws there. It will get impact to get your case admitted as early as possible on first hearing. It is most difficult argument is when I come from Bombay, I go to Supreme Court. That time I have the proud. Yes, I have the experience of 29 years of law. So this is now one court ahead. But arguing in all court till High Court is a different, and arguing in Supreme Court is a totally different. When I argue my first case, that time I comes to know Supreme Court is a different court. So my practice year is first year now. My all earlier practice is 0 year. I have to start, initiate my practice again with the need of the Supreme Court. And all judges are excellent and clever. So all my 60, I think, Pooja, how many books we published till now? 62, no? 61. In all my 61 books, I have dedicated their books to Supreme Court judges. With the grace of Lord Krishna, I got the grace to publish these 61 books. Just go on Amazon or Flipkart, type Jayprakash Somani books there. You will find my all books on Supreme Court case laws on different topics, different as per need of the common people. So anybody can buy it on Amazon, Flipkart at national level and at international level also. Amazon UK, Amazon USA, these books are available. So what is the meaning? When we focus any one court, that time we can create some image, create some sort of confidence there to work there. Even though you are from vernacular medium, we will face a little bit difficult. We cannot speak fluently in English like a convent school student or English medium student. Because I am from Marathi medium student. Till 10th standard Marathi medium. Till 12th standard also Marathi medium. From 12th onwards in BCom I have taken English medium. But what is the comparison of vernacular medium students and English medium students? The basic understanding and fast thinking power, vernacular students have more as compared to the English medium students. Because of mother tongue, you are getting better understanding. Just try to convert that into English. And after due practice, you can sufficiently argue in English, and nobody expecting from even though in Supreme Court, no judge is expecting your English should be a very fluent. Because judges are also from vernacular languages. Only few judges like our Chief Justice Chandrachud, few judges maybe there, those who are taken their education in convents.
but many judges are from vernacular language. Sometimes we don't remember that particular word. Judges are suggesting, or our colleague lawyer are suggesting us that question. That word is in our always there in brief. But when we are arguing without observing the brief before the court, that time all of a sudden, sometime up, we lost that particular word, and at that time, anybody can suggest us that. So that is the regular habit. Your confidence is very important in advocacy. Very important. But I will take, I think I will take 1, 2, 3, 4, like that, some Nani Palkiwala series for English vocabulary only. Yes, I have 1,000 words, English words. My one enter, क्या नाम पूजा वो इंटर का जिससे हमने करवा लिया था ये सब? श्रीलता. हाँ, one Srilata was enter. So when inter joined me, I am getting some research work getting done from them. So I got them. So I have given all important speeches, Chandrachud speeches, all High Court judges, Supreme Court judges speeches to her. I have already, this is my hobby to learn the different videos, watch the different videos law regularly. Regular morning exercise, I am regularly watching law videos. At night also, I am watching the water. I am watching my videos also again and again for getting memorization, for getting more understanding like that. And I am watching other videos also. So I have given her 8 to 10 videos and told her, you find out the new legal words and make the, so 1,000 legal words practically we have with us. And I want to share that all words with you. And we will not only see the word and its meaning, we will see its practical application also. We will add in one line also that particular. So unless and until you are using English vocabulary into your day-to-day practice, day-to-day argument, your English will not improve. Whatever you are watching, English movies, English videos, English series, English news, but when you are not doing the practice of speaking English, your spoken English will not improve. So in front of mirror, regularly try 30 to 40 minutes. 30 to 40 minutes speak in English. Initially, you will fail grammatically speaking. When I will start this session in Nani Palkiwala vocabulary in English. There is my separate one recorded course on my app. Jayprakash Somani app is there. You can go, or you can send the message to my PA, Pooja Rai. Send me the links of Somani sir's Advocate Somani's recorded courses of law. I have 2 types of recorded courses: legal related to law, 7 to 8 courses for law, and 7 to 8 courses for export-import business. Both are different segment. So recorded courses are there. So one recorded course is there. Argue in English in High Court and Supreme Court. The name of course is that. But that recorded course was a very deep course. So anybody can access for 2 years like that video. You can enjoy whatever at any time. But in Nani Palkiwala series, I will cover that 1,000 words of legal English, which will be helpful to you as well as me also to improve our vocabulary. So these are the significant point to argue in Supreme Court. Instead of focusing on the English language, it is better to improve your English, definitely better. But instead of focusing on your improvement of your language, if you are focusing the understanding of legal concepts properly, using of properly legal maxim, using of properly legal doctrines, okay. So such type of, when you are focusing daily, that time you are capable to argue in high courts and Supreme Courts. At international level also you can argue in international arbitration matter. international arbitration matter. Arbitration is nothing but arbitration is like a trial court. But the judges are there, the members on that arbitration tribunal are more excellent than you and than ordinary judges also, because many times Supreme Court retired judges, High Court retired judges are the members of the arbitration. So these are the little bit my sharing practical tips of advocacy through the viewpoint of myself, and these are my practical points. I have not copied from any books like that. Okay, so these are my practical times. Some points maybe you like, some points you may not like. I'm not insisting all my points are correct. No, it will differ to area to area, differ to person. Okay, but with the grace of Lord Krishna, I will say from very small village. My village is Takleban, Taluka, Shrirampur, Jilla, Ahmednagar, Maharashtra. Maharashtra State, Ahmednagar District, Shriram Tehsil and Takleban village. I born there. Up to 10th standard, I learned there. Then I shifted my education to Tarisik, Shrirampur. College education I completed, BCom education. Some part I completed of law in Ahmednagar, some part of law I completed in Pune. I started practice in Tehsil Court. Then I started practicing, shifted practice to High Court, District Court, then shifted practice to Bombay Tribunal, Sestat Tribunal, Excise Custom Tax, like that. I'm always interested in challenging cases. I'm not interested in ordinary cases. Ordinary cases are coming, I'm interested. But I always get happiness when challenging cases come first. And then I shifted to Supreme Court. So all these are journey from small town to Supreme Court and to up to international arbitration arguments. So all these of journey because of the only liking of your challenging cases. So I hope you understand what I'm saying, and I hope you are more talented than me. So you will develop your practice much better than me also. And my best wishes to all of you to develop your practice in all round ways and serve to hold humanity, because we are in very noble and very good profession where we can give speedy and proper justice to the needy people. Thank you very much. Now, Manoj, give me a few seconds. I will unmute you again. Manoj, you can unmute yourself.
Thank you very much, sir. Thank you for sharing such a great experience, practical experience, that too from the Tehsildar to the High Court, then to the Supreme Courts, and how we can use our English in a better way to argue. Thank you very much, sir, for sharing that practical experience. Thank you all participants to be here and consciously listening the videos. Thank you very much.
Thank you. Bye.
नमस्कार, मैं पूजा राय आपको एडवोकेट जयप्रकाश सोमानी जी का थोड़ा सा परिचय करके देती हूँ। जयप्रकाश बंसीलाल सोमानी सर्वोच्च न्यायालय में अधिवक्ता हैं। 12 जूनियर के साथ वो लॉ फर्म चलाते हैं, जिसमें 5 AOR हैं। सोमानी जी भारत के हर राज्य और केंद्र शासित प्रदेश के मैटर बखूबी हैंडल करते हैं। सुप्रीम कोर्ट केस लॉ के ऊपर उनकी 61 किताबें प्रकाशित हुई हैं, जो Amazon और फ्लिपकार्ट पे अवेलेबल हैं। लिंक आपको नीचे डिस्क्रिप्शन में मिल जाएगा। भारत के लगभग सभी हाई कोर्ट और डिस्ट्रिक्ट कोर्ट के अधिवक्ता इन किताबों का उपयोग करते हैं। अगर आपको सोमानी जी की गाइडेंस अच्छी लगती है तो नीचे कमेंट बॉक्स में जरूर लिखें और अपने दोस्तों के साथ शेयर करना ना भूलें। हाँ, अगर आपने चैनल को सब्सक्राइब नहीं किया है तो सब्सक्राइब कर लें और बेल आइकन को दबाना ना भूलें, ताकि हमारा कोई भी नया वीडियो आता है उसका अपडेट आपको मिल सके। जय हिंद।